Yo, 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 Florida employment lawyer JP. I'm going to talk to you today about how you prove your case. Okay? That's right. Discrimination, retaliation, sexual harassment, sexual assault, anything in the traditional plaintiff side labor and employment wheelhouse. This is how you actually prove your case. All right? Trying to help you, trying to empower you so you can learn how to be a better advocate for yourself. Okay? Let me just explain what I mean by that. All right, people, you have to help yourself. All right. If you think of yourself as a powerless victim who's just kicked around by the world and has no power to do anything to help yourself or to advance your own position, your own standing, your own leverage, right? Then I can't help you. I don't want to help you, right? I like to help people who want to help themselves, okay? Let me do the law part, okay? But there's a part you have to do, and that part is the fact part, okay? So let's just get into the mix. When you get involved in litigation, all right, you might call our office on the phone and you might tell us this, this story, right? This version of events, okay? And one of the things I see a lot of the times is I see somebody only has, kind of a limited perspective of what happened in the company, right? This is what they see. This is their view. But there was all this other stuff going on, okay? So from what they see, okay, they think they have a strong case. They think they were terribly discriminated against. This is so wrong. Their rights were violated. But when you look at all the other facts and circumstances, you realize, no, they weren't. No, they weren't. They think they were discriminated against because they only see this right here, okay? But you look at all of it, no, there's no case there, okay? But let's put that aside, right? Let's say it's a case where you do have a real and a strong discrimination claim, okay? What happened to you was discrimination. It was illegal. It was egregious. There was retaliation, the whole nine. Let's say you have a very strong case, okay, in terms of what actually happened. Is that enough? Okay, I hate to be the resident bald-headed jerk-faced meanie, but that alone is not enough, okay? That's not enough. Just because something happened, it was wrong, your rights were violated, that's the truth, right? Unfortunately, this is the American legal system. This is litigation. This is not a fairy tale, and this is not an episode of Suits, okay? No, you are not getting assigned the most important case in the firm tomorrow as a first-year associate because somebody got sick with the flu. It's just not going to fucking go down like that. All right, friendo? But when it comes to litigation, okay, the harsh reality is your case is only as strong as what you can prove. So if we're talking about what's the truth, right? Maybe the truth is something terrible happened. It was wrong. It was illegal. It violated your rights. But if you can't prove that, you're not going to get anywhere. Now, how do you prove that? Okay, mechanically, what are the sources of proof? Well, one, there's your testimony, okay? And your testimony is a valid form of proof. The strength of that evidence, the strength of your testimony, well, that all depends on you, okay? If you dance around, you beat around the bush, you dance around the issues, you evade, you try to be cagey, you don't have clear answers, then yeah, your testimony is worth nothing, and in fact, probably sabotages and blows up your case. But if you have clear answers, direct, to the point, right? Okay, now you're getting somewhere. Now your testimony is potentially a significant source of evidence. Documents, okay? Number two, documents. Documents are a significant source of evidence. But the problem is companies routinely either A, delete, destroy documents, or B, they hold the documents back and don't turn them over when they're supposed to. So you have to file what's called a motion to compel. You have to have a hearing. You have to get a court order forcing the company to turn over the documents. And oftentimes, even then, companies wait until the very end of the case to turn over really damaging evidence. That sort of thing happens all the time. It's absolutely preposterous and inappropriate and violates the letter and the spirit of the rules, but big companies unfortunately do that in litigation all the time, and they routinely get away with it. That's just the nature of the system, okay? So you can't really expect to obtain much leverage via documents unless they're documents that you come into the case with, right? If you have this stuff from the jump, if you have copies of documents from the jump, that's going to give you a significant leg up. And that gets into why you always need to retain copies of any central documents, okay? If you send an email to HR where you lay out the discrimination you're facing or the retaliation, you can bet your bottom dollar that that email, especially if it's good, especially if it's surgical, especially if it's unimpeachable and it's true and it's got bullet points and it says exactly what went down and how you were discriminated against and what it was on the basis of and specific people's names, specific dates, specific incidents, okay? You bet your bottom dollar there's a good chance that email is just going to disappear up in the wind, right? We don't know what happened to it. We don't know what happened to it. We had a fire. We had a fire, right? You believe it, okay? Isn't this crazy? 2024. And within the last 3 years, I have heard we had a fire at our warehouse where we keep all the documents, right? You keep boxes of documents, right? Of course you do. Of course you do. Because then there are more plausible excuses for what happened to those documents and how those documents disappeared. This really is corporate America, folks. This is the American corporatocracy that your overlords have built, and this is how they get down, right? We have documents in paper because that way we can have a fire, and the documents that are bad for us, they can just disappear, right? So unless you have copies of it, don't expect to get much leverage out of documents. Yes, sometimes the other side, if they have lawyers who are very ethical and honest and on the up and up, and there are some of those folks out there, okay? There are some lawyers like that on the corporate side, on the management side, and you might get some good documents in those cases, but in at least 50% of cases, you just have to assume you're not gonna get any good documents to prove your case, okay? What's that leave? The other side's testimony. What are the odds of the other side saying, you know what, really is crazy, but we did have a no blacks policy, crazy, right? We had a policy where, we hired the guy, we gave him a chance, we did have a lot of racism, a lot of the N-word being thrown around, a lot of harassment, some stalking, intimidation. And the client, Jerry, right? Say, call him Jerry, right? Say, yep, Jerry reported it all. He reported the harassment, intimidation, racism, and, we told him not to make waves, and then he complained again. And so, we did just fire him, right? So we had an environment with lots of blatant racism and discrimination, which we know was illegal. And then when he complained about it too much, we just got rid of him. So, you got us. You caught us. You got us red-handed, right? Nobody's ever going to do that. Nobody's ever going to do that. Even I've had cases where there is a smoking gun document that says XYZ, and the company says, XYZ never happened. It was ABC. It was ABC. What about this document where you say it was XYZ? I can't explain it to you. I wasn't involved in that. I don't know what happened, but I can assure you that's just not true. It's on paper. It's not true, right? So the company is going to lie about whatever happened. The company is going to advance its own fictitious version of events. So, in lieu of getting the company to admit the truth and back up your allegations, your story, your narrative, your version of events, in lieu of that, because it's basically going to never happen, you can just catch them in lies, okay? Remember that, all right? Hugely important point. You don't necessarily have to prove that the company discriminated, retaliated, etc. You don't necessarily have to prove that, okay? You can testify to that. You can say it happened. And I apologize, this is a little bit higher level of a doctrinal point because you do have to prove discrimination, but follow me here, all right? Follow me here. You can testify to the discrimination. You can testify to the retaliation. You can say that's what really happened here, okay? You don't have to catch the company or get the company to say, yes, it happened. Yes, it was discriminatory. You just have to catch them in lies, okay? This is so significant, people. Legally, that is called pretext, okay? If you prove that the other side is lying, right? Say they give a false reason, right? They give a false reason for termination, okay? a great example from the case files, okay? Disability discrimination case. So the person has an accommodation. They're doing the job there, and I've seen this fact pattern multiple times, okay? Multiple times. They're doing the job. Say they do it for 2 years, doing the job. They have an accommodation. Everything is just fine. New management comes in. New boss comes in. New supervisor comes in, okay? And he says, yeah, I don't like this accommodation you're getting, so you're put back on the sort of regular program, regular requirement, whatever, right? No accommodation, because it's just not good for the business. We can't give that accommodation. It's just not, it's not realistic. It's not reasonable. Our business can't tolerate it. It's bad for business, 6 million other reasons, but we just can't accommodate you. So you have to go and do it, this other way, right? Never mind the fact that you've been doing it for 2 years this way and you've got great performance reviews. The accommodation you want is it's too much of a burden for the company, okay? So we're revoking the accommodation, all right? You have a situation like that, okay? Say they fire the person. And they say, no, it's performance, okay? It's performance. We did a performance review. If you look at her performance review, yeah, her performance reviews were good for a while there, for almost 2 years. But then her performance just really fell off and went downhill. And so we had to get rid of her, right? And so you say okay, so this performance review, right, where she fails terribly, you say it's not up to standards, you recommend termination, right? This performance review, that's a regularly scheduled performance review. Oh, absolutely. Yep. It's just a standard, right? It's a part of everybody gets one, right? We do them every year or so. Well, hold on a second. This performance review, she just had one 3 months ago, right? You say you do them every year or so? She just had one 3 months ago. This isn't a regularly scheduled performance review. You gave her an extra performance review so you could trash her performance and then get rid of her and use that as a justification for getting rid of her. That's not true. A new manager came in and he wanted to do a performance review, so he did one, for certain employees. Well, not for everybody, right? I don't know. I can't speak to that. I just know he did it for some employees. Why for some? Why for an employee who had a spotless track record for 2 years, but just happened to request an accommodation for a disability? Why that person? Why was that person singled out for a performance review? It was standard practice. Like I said, several employees got one. Were they employees who had disabilities and needed accommodations, or possibly black employees complaining about racism, or women who wanted equal pay? Oh my God, were those the people who got the extra performance review where they got their performance trashed and you got rid of them? Oh, wow, right? Very clever. That's the kind of stuff we're talking about, people. That's the kind of stuff we're talking about. In cases like this, okay, really good chance you're never going to get these people to go on the record and tell the truth. You're never going to get these people to admit that there was discrimination, retaliation, that what they did was illegal, okay? But you very well might catch them in a lie, okay? And the more lies you catch them in, the more significant lies, the more concrete lies, the more direct and provable lies, the stronger your case is going to be, because you can build a case in this arena either through direct evidence or through circumstantial evidence. And when you catch the company in lie after lie, that is a very compelling piece of circumstantial evidence. And it suggests or weighs in the direction of your story actually being the truth, right? The company's lying. The company is trying to cover everything up. Why are they doing this? Because you're actually telling the truth, right? That's the direction this stuff goes. That's the importance of pretext. That's why, number one, you have to have documentation, right? Copies of anything and everything, complaints you've sent, whatever you've corresponded with HR, right? Key documents, smoking guns, anything like that. You got to have copies of that. You have to have your own narrative, your own story, which is the truth and to the point and just the facts, and not a bunch of emotional, long-winded nonsense. Okay, just tell us what happened and be honest about it. But then on the corporate defendant testimony side, you're not going to get them to fess up to it. You've got to work on catching them in lies and establishing pretext. And that's going to go a long way towards helping you to prove and hopefully win your case. Jonathan Pollard, Florida employment lawyer. Thanks for watching and have a good day.